People are coming in. Hello, Emily. Nice to have you back. Catherine, Keith, Lewis, so much more names coming in. Please let us know where you're tuning in from, or what brought you here um, this afternoon or evening, wherever you are. Okay, and we'll just go ahead and get started. Hi, I'm Omar Acevedo, and I'm the Literary Program Coordinator here at the Mark Twain House and Museum in Hartford, Connecticut. Thank you for joining us for this virtual program for Who Owns This Sentence? A History of Copyrights and Wrongs. Virtual programs like this are produced in part with support honoring the late Frank Lord. We are grateful to honor his memory with these programs. And I also want to thank our members. I know there are at least a few of you here in the audience. If you're not a member, please consider supporting our museum by becoming a member. There are so many benefits to becoming a member. You don't necessarily have to live close by because you will receive free or discounted admission to our author programs, free admission to the house and museum, and year-round discounts in the store, which you can purchase things online, and many more benefits to becoming a member. Please visit our website for more information or just reach out to me and I'll send you over to our development office. Now on to our guests. Our first author is David Bellos, the Meredith Howland Pyne Professor of French and Comparative Literature at Princeton University. He is an award-winning translator and biographer and the author of Is That a Fish in Your Ear? And the novel of the century. Our second author is Alexandre Montagu. He is a practicing lawyer and founding partner of MontaguLaw, which focuses on intellectual property law, international commercial transactions, and new media commercial and corporate law. And our moderator for today is our very own Mallory Howard, who is the assistant curator here at the Mark Twain House and Museum. During this event, we encourage you to have a conversation with each other in the chat. But if you have a specific question, please post that directly into the Q&A section, which is at the bottom left of the screen. And that's all for now. I'll turn this over to David, Alexandra, and Mallory. Please sit back and enjoy.
Perfect. Thank you so much, Omar. And thanks to the both of you for joining us for this conversation. I absolutely loved your book. I found it fascinating. I really didn't know very much at all about copyright. And now, thanks to your book, I feel like I've gotten a better handle of it and think it's quite fascinating. So I'm excited to have this discussion with you. And really, my first couple questions are kind of about your process and how this all began. So the first one is really, why did you decide to write this book? And how did you both come to know each other?
Well, it's all the fault of Alexandre Montagu. He's entirely responsible for this project from its inception, and maybe he should tell the story of how he came to bludgeon me into learning about copyright.
I don't know if he can hear us.
Oh dear, can you not hear Alex? No, he obviously can't.
Looks like he's putting the story on you then.
Well, I just have to tell the story.
Can you hear me?
We can now.
Oh, we can hear you now.
Yeah, I'm not. It looks like I'm having some technical difficulties here.
Can you hear us okay?
Hear you.
Let me see.
I can't hear you. I'm sorry.
Well, maybe if you turn off your camera, would that help?
No, well, you can't hear that. So, well, I'll tell the story because I know we've got people watching. Alex was a very brilliant student at Princeton a long time ago before I got there, and did a degree in comparative literature. And then he went off and became this horrible thing called a lawyer. But in his distinguished career as a lawyer, he also got inveigled into becoming a member of the Comparative Literature Department's advisory board, which kind of external board that comes and looks at us once every couple of years. And at one meeting, he challenged the department. He said, "Why don't you teach students of literature about copyright? Because it's absolutely fundamental to everything you do. I mean, to translation rights and authors' rights and so forth. And since I'm a bit of a muggins, and I also knew a little bit about it from my work in French 19th century book trade, I said, all right, I'll have a go. And so that's how we came to know each other and how we put our heads together and put on a course to teach students about the history of copyright and its role in the development of Western cultures. And that we taught, I think the first time was 2017. And we taught it together. And Alex very bravely came down from New York every week, in fact, twice a week, to join in the seminars and the lectures. And it was quite successful. So we taught it again. And then Alex decided to move his entire business and himself and his family to London. So we can't really teach the course again. So we decided the only thing to do was to write a book about it.
Wow, that's a great story. I love that. And now it's interesting because you both come, you both have different professions. And how did you write the book together? Was there a certain technique that you used to be able to put together the chapters and each add your specialty or your knowledge to the book?
Well, since we taught the course, we had the syllabus and the bibliography and the references, and basically I wrote chapters and Alex corrected them and told me where I was wrong, which was quite often, and it kept me on track. And we knew from the beginning roughly what the shape of the book would be, but then, with going back and forth, mostly by email, actually, we added things and took other things away and so forth. So it was a collaborative venture in that sense, but the actual writing of it was me, because I do that sort of thing.
Very interesting. And how long did this whole process take you?
Well, I guess we started if you started in 2017 when we taught the course for the first time, it's now 7 years. But actually the book was as good as actually written in the years 2020, 21. But then it took time to find a publisher and then an American and so forth. So it's been pending for a couple of years.
Fascinating. Well, to get into a little bit about this, and of course, working at the Mark Twain House a little bit later, I do want to touch upon Twain and his own battles with copyright.
Yeah.
But I did read something where he said, who does copyright really protect? And so that actually leads me and Mark Twain are really asking our first question of, in your view, who are copyright laws supposed to protect in your viewpoint?
Well, it's not really our viewpoint. The claim of all the early laws on copyright, from the Statute of Anne in 1710 down to the American laws of 1790 and the reforms of copyright law in the 19th century to the Berne Convention of 1886, were all nominally and publicly designed to encourage learning or to support creators, to protect, the French call it, artistic and literary work. So the verbiage, as it were, the discourse around copyright is all about supporting, encouraging, and protecting authors. That's much less true now, especially since the 1976 US copyright law, which is the one that's now valid together with various amendments. But also it's true of the European and the British laws of the late 20th century. And that's because author has had its meaning expanded and expanded. Author now just means the owner of the rights. And the owner of the rights may, of course, be a corporation, and very often is a corporation, or a publisher, or somebody to whom the author has ceded the exploitation of those rights. So it really has now less and less to do with actual creators and more to do with the entities that own the rights or that own the license to the rights. And those people, bodies, the laws certainly protect very, very firmly.
Alexandre, do we have you back?
I believe so.
Oh, good. Can you hear us?
I can hear you now.
Oh,
Yes,
wonderful.
I'm sorry about that.
Okay, good. Glad to have you back. Well, David, what you just said kind of segues nicely. One of the things that really surprised me was you guys talk about basically the 6 major corporations, Microsoft, you listed, Disney, Amazon. They have the vast control over copyright material. Can you talk a little bit about that? Because I was surprised that the 6 companies or organizations that you talk about own so much of it.
Well, that is, I'm not sure it's quite true to say that they own so much of it. It's that copyright is the foundation of their empires. Largely because, I mean, the case of Disney is slightly different, but in the case of the software companies, it's because since the 1970s, computer programs are not things that need to be patented. They are copyright. Copyright is much, much stronger than patent because it lasts, in the case of a corporate copyright, for 95 years, which is a very long time indeed. So it is, by definition, much more valuable. Disney, of course, is a huge entertainment corporation and owns the rights to a vast splay of movies and other copyrighted materials. So it's a little bit different for these different companies, Amazon, Disney, Meta, Google, and Facebook. But after all, Microsoft's fortune is based on the MS-DOS operating system, which is just a computer program, and it's that computer program that is copyrighted, and that seems to me to have almost nothing to do with the origins and intentions of the drafters of copyright laws, but that's the way it's turned out. So that 6 of the biggest and richest corporations in the world have a capital value that is predicated in large part, obviously not exclusively, because they also own other things too, but in large part on the intellectual property that they control.
And
Interesting.
I can add to that.
Sure.
In that, I mean, the point that we make about the big 6 is, they're not the only corporations, obviously, that have this. And the point is that, as David was saying, the origins of copyright and even the way that we talk about it and we consider it and we look at it today is that it's there to reward the individual for creativity. I mean, that's the bedrock of, all of the discussion that we have, and whether it's in the legal community in the context of drafting the laws or enforcing the laws, or whether it's in the context of whenever something comes up in the media, it's always there. And it's also an argument that's being advanced right now in the context of artificial intelligence and whether or not these AI tools, the machine learning tools, should be allowed to use copyrighted material to learn. I mean, that's a burning question right now that's going on. And the argument is always, well, the copyright is there to protect the individual creator. And those are the arguments that are advanced in the cases now as well, in the AI and machine learning cases that are going on. And also in the UK this past year, a draft legislation that would have allowed machine learning to use copyrighted materials was withdrawn because of was an uproar that it's going to basically demolish the creative industries. And again, the arguments that were being presented were, well, individuals aren't going to create if they're not, if the AI could do this. And I'm not here to support one side of the argument or the other in this case, but I'm just saying that we wrote the book. One of the things that we consider in this book, is that correct? Is copyright really doing that? Is it fulfilling its original purpose? Or has it become something completely different, which, as David was just saying, and as we wrote in the book, it seems to have become actually, a feather in the cap of big business, rather than something that is, rewarding the individual creator to create more.
Yeah, perhaps we should chip in at this point, Alex. The two key moments when this transformation happened. One is in the early 20th century, when in an American copyright reform law of 1911, there's just a little paragraph that says, in the context of this law, author may also mean employer. And at a stroke, and it's one sentence, you transform copyright from something that adheres exclusively to people to a mechanism that can be owned and operated by corporations. I don't know whether anybody really noticed at the time, but people certainly noticed in the decades following as companies began to discover how to use it in order to build quite substantial empires in book publishing, audiovisual and movie industries. The second key moment came in the 1976 US law that I've referred to, where there is there's just a little line that says a computer program is a literary work. It actually says that for the purposes of this law, literary work may include computer programs. So those two things, that corporations can own copyrights, irrespective of whoever actually made the stuff. And second, that, if you make a computer program, then it belongs to the company that employs you.
Right.
Yeah, I mean, if you think about this, if you go back to the 18th century when the law was actually written and decided and it went down, initially the protection was only a 14-year term of protection for books only. And in the 18th century, books were not the driving engine of the economy. It was land. And so this didn't really affect, this didn't really have a major impact, I would say, on the dominant sort of engine of the economy. But if you fast forward to the 21st century, land is important, of course, but it's no longer the dominant engine of our economy. What is the dominant engine of our economy are these intellectual property laws. And as David was saying, copyright, because of its term and because it doesn't have to be registered, has actually overtaken patents. With a
by a long way, yeah.
Yeah, with a patent, it's actually quite difficult to get one because you have to go through the patent office, and copyright just comes into being as soon as it's created. And it lasts a very long time. And now this is the dominant engine of our economy. I mean, as David was just again saying, if you look at everything that underlies these corporations, the value, it's not land, it's not the office buildings, it's the intellectual property. I mean, without the intellectual property, I would say that the values of these corporations, if you took the intellectual property away, what would remain? I'm not really sure.
Right.
So, this is what's happened, and one of the things we explore in the book is that it's sort of, nobody sat there and said, okay, is this what we want? It wasn't actually decided. It was just really a happenstance of history. Do you know how it went down?
Well, yes, the many of the things that we chronicle in our book, which deals with the long history as well as the present of copyright law, are a series of entirely unintended consequences, some of which are really quite funny. The funniest and the most sinister, I suppose, is the emergence in the early 20th century of those lovely old devices called player pianos. Mechanical pianos that you'd put in a restaurant or wherever, and you'd switch it on and it would play a tune. And it played a tune because the musical score had been transcribed into punched paper tape and the mechanical device would wind the tape through, and the holes in the paper would operate the different keys on the piano. And so a little argument arose. The restaurant owners said, well, we've bought the machine and the paper tape is part of the machine, so we own it and we can play it. And the music publisher said, oh, no, you can't, because those paper tapes are copies, are transcriptions of copyrighted sheet music that we own, and you owe us some money every time you switch it on and perform it. The dispute was resolved. It was resolved in a quite interesting way that gave rise to compulsory licensing of music. But more importantly, this resolution of that argument was that, yes, punched paper tape is a form of writing. Now, they did not know in 1911, 1912, when they did this. They had no idea that 50 years later, those early calculating machines that we now call computers would be operated by punched cards and then by punched paper tape. And that's how computer programs come to be copyright material. That is exactly how. There is no other reason why they are treated as proprietary under the laws of copyright. So, I mean, that's obviously an unintended consequence. I mean, it just happened, as Alexandre said, it's kind of a happenstance. But my word, people need to know that they are the prisoners of something nobody really thought about until it happened.
And, you know, I mean, it's an urgent time for people to know. And the reason is that we have a new form of property called artificial intelligence that is coming down the pike, and no one knows what this is looks like, but it's raising some really important, and I would say existential issues. And one of the main ones, which I don't think is really getting enough debate, is this question of ownership. You see, and the concept of ownership in connection with artificial intelligence comes up in several different ways, none of which are really being debated as a whole. You know, we're not sitting down as a society, you know, and debating whether we want this or not. You know, and it seems to me that what David said happened with the sheet music, which was that one decision in one case, and then it went on, and then it was sort of built on, and then suddenly, you know, all computer programs fall within the scope of protection of copyright. Okay, so with artificial intelligence, someone creates that machine and will own the rights to the underlying code. Right? So whoever creates it, the corporation, or it's likely to be a corporation that creates it, will own that particular machine. Okay?
And then whatever it produces, correct?
Yes, the output
That's
of
the question. That's
right.
the question. What will be the property status of the outputs of AI devices?
Okay, so that's
that is really crucial, because if it's held that the outputs belong to the owner of the program, well, then we'll all belong to a corporation very quickly. If, on the other hand, it's decided that it doesn't belong to the corporation, but to the person who operates it, we're going to be given property status to stuff people haven't written.
Right.
So those are clearly very, very significant issues that I don't think have been thought through and are just being, you know, decided basically by the courts here and there.
Well, to be fair, the Library of Congress, the Copyright Office and the Library of Congress are conducting a public inquiry at this very moment, and submissions to it are being made by various bodies and interested parties. But where that will go, I do not know. It's still in progress, and they haven't asked me or you.
No, I mean,
to come and tell them.
I did comment on that. It's true. I did comment to the Copyright Office.
Oh, I didn't.
It came, and I did comment on that, And I suppose in some ways it is it's a good place to start. But I would think that we would need a much broader dialogue, a lot more input than the few people in front of the Copyright Office who are doing this. I think that everyone on this, I think it should be treated by the media as a very important issue for all of humanity rather than a niche issue for the Copyright Office. You see what I'm saying? I mean, that's the point. And the other part of this, which is also not, is that these things, the machine learning as it trains, it has to use all kinds of copyrighted material. And, whether or not it should, be allowed to do that without compensation. If they provide compensation, who gets that compensation? These are, again, issues that need to be debated. And I think one of the things that our book does, sorry, just to finish on this, I think that one of the things that our book does is sort of, it ends with that saying, we got to this point by just happenstance, nobody really paying attention. And now we're asking everyone to stand up and pay attention to this issue because we think it's really important for everyone.
Well, and I think that's such an important point and I'm so glad we're having this conversation because I think part of the problem is it's not out there for the general public. I had never thought about AI or creative license and copyright and things like that until recently, because we do get a lot of authors at the museum, and a couple authors had said, they were in the midst of lawsuits because there were stories of AI who would be fed information of, can you write a chapter in the voice of this author? And the AI would produce something that sounded just like that author. And I was so surprised and somewhat horrified by this, but had no idea, didn't really think about this going on. So I think this is such an important discussion to make people aware. And part of it is, do you think that, why do you think the media, the mass media, hasn't been more outspoken about that? What can people do to help bring awareness about this issue?
Well, write a book to begin with.
Yeah, you guys have made a great start.
Yeah, I mean, I'm really glad you asked that question because I think the answer is that people deal with this as a niche issue.
Mm-hmm.
They deal with this as a niche legal issue. Like the very issue you're talking about, whether or not an AI that can replicate an author's style or voice, should that or should not that be allowed to happen? That's analyzed in the context of our existing copyright laws. And our existing copyright laws were not written with this in mind.
Right.
So, judges are sort of throwing their hands up. I mean, we had a recent case, a big case between Oracle and Google, where the question was whether APIs are copyrightable and whether Oracle could assert copyright on that. And it took 10 years of litigation, up and down the various courts. And in the end, the US Supreme Court threw its hands up and said, we're not going to decide that. We don't know if APIs are copyrightable. We're not going to decide that, but we're going to decide that even if they are copyrightable, Google's use was a fair use. So we're going to decide the case on that. So we have the problem that we've got a technology coming down that is not really suitable for being, resolved under this law. And yet we only look to this law to see, to determine the boundaries of this technology. So if you say to me, you would come and say, well, Alex, should AI be allowed to do that? And when people ask me that question, it implies, does existing law allow them to do that? And I think that's why we wrote this book. We said, okay, this is the existing law, and we're not really even sure where it is, but we need to have a public debate right now as to whether or not this law is able to deal with this technology. And if the answer is not, then what are we going to do? What's going to replace it? You know, what we're saying is it should not be a given that you're going to have, you look to copyright to decide everything about
cultural
machine
issue.
learning. Yeah.
Mm.
Because this was a law that was written for at a very different time for a very different product.
Right.
I would add to that. I think it's, I mean, because I'm a sort of academic and a nerd, I do think it's important that people learn from the history, because the history of copyright is a history of misunderstandings, unintended consequences, happenstance, greed, and complete mistakes as well. And people need to realize how significant it is. That it really does. You really do have to think about what words you use and think forwards, because if you don't, you end up in the sort of mess we're in now. So I think it's very good that people should have at least some understanding of the funny little twists and turns and crazy things that happened and that have bit by bit turned copyright into what it is today.
Exactly. I mean, the story, you know, and I think the book, I hope, and I truly believe the book is written in a way that anyone can pick it up and read it. You don't need to know anything about copyright. You don't need to know anything about law at all. Anyone can pick up this book and read it. And it tells you the story of how did this happen? You know, how did we get here? And until you know that story, you know, you're probably not, you're going to say, well, what does it have to do with me? Okay, yeah. But once you read it and you'll say, and then you realize, okay, well, actually, it has a lot to do with me. As you're saying, your authors are just one of, but we're all going to be touched. We're all touched by this. By the way, we are all touched by this, not to mention, I mean, you know, there's huge debates right now about inequality and what's going on. And one thing that, you know, one thing that is also important in the context of those debates is the issue of intellectual property. So I think reading this book will really fill you in on that in a sort of readable, lighthearted, storytelling ways. As David's saying, I mean, we tell stories in the book.
Right. Well, and that's the thing when, you know, when I first heard about a book about copyright, I have to say I was a little intimidated. I don't really know that much about copyright. But like you said, the book is so easy to read. And the fact that you both take us through the history of copyright and still connect it to what's happening present day is so important. And so that's a great answer to the question. Is this is a great way to start educating yourselves about the history of copyright and really the present and the future of it, because like you said, it really is going to affect us all. And I think the other great thing, which leads to sort of my next question, is it does teach you and define phrases that may have been confusing. So for example, if you guys can talk a little bit about the difference, for example, between copyright and plagiarism, which I think can be a little bit confusing.
Yes, it really is rather lamentable in which the way lamentable that the two things have got muddled up in most people's minds.
Yes.
Plagiarism has been an offense against honor and good practice since the days of Plato. I mean, for over 2 millennia, long before anybody ever thought of property right in created work. It's not about copyright at all. Plagiarism is about proper behavior. And the only reason it has got into arguments about copyright is that the 1976 Act gives the owner of the copyright control over all derivative uses. Now, you might say, well, that's fine. I mean, like, of course, the owner of the rights to a novel should have some say in how it's translated or how it's put on screen. You could, I mean, some people would say no, they shouldn't, because for most of human history they had no such control. But that has been taken to mean that they also have the right to grant or withhold permission for the reuse even of small snippets of a book or a movie or a poster. And this is, to my mind, a kind of cancerous growth on the copyright law, that people now try to use it, and do use it. And publishers fall into this and ask for permission, even for the tiniest little bit of quotation of another book. That's how plagiarism gets into it. But plagiarism is not an offense under the law. It's not mentioned once in the 200-page long Copyright Act that rules the United States, or in the Copyright Acts that rule the UK and the European Union. It's entirely outside of that. But even judges and lawyers get themselves muddled up and start trying to judge whether this work plagiarizing, especially in the music industry, where there are a lot of prima donnas who say, you stole my song, etc. Well, maybe, but the only offense would be infringement, copyright infringement, which is conceptually a different matter, but it's hard to tell when the song's only got 5 lines of verse in it.
Exactly. Yeah.
So another question I have, and you may have already answered this, but throughout copyright's history up until today, when we're kind of talking about AI, is there an anecdote or a point in its history that you both find the most frustrating about copyright? Something that angered you or frustrated you about it?
Well, frustrated, I don't know, but I think the rot goes right back to the start. And the one that is, it's both the most entertaining and at the same time the most infuriating moment is when the British artist William Hogarth Esquire, you know, the engraver of the Rake's Progress and so forth, had this bright idea with other bibulous companions in an organization called the Beefsteak Club in London, to petition Parliament to extend the copyright from books, which is what it goes, to engravings. And he had 2 arguments. One was that when an engraving is included as an illustration in a book, it is covered by copyright because the book is copyrighted. The second was that engravings are the products of a press. Books are the product of a press. Therefore, they should have equal protection under the law. Leaving aside, I mean, it's a pretty dodgy argument, leaving aside that the kind of hand press on which you print engravings is completely different from the movable lead type printing press in which you print books, and leaving aside the fact that orange juice is also the product of a press. And it's the kind of the self-interested false syllogisms used in that case in 1735 where the rot begins, because people from that point on started using similar analogical arguments, you know, this is like that and therefore it should be, etc. And that's how copyright grew and crept. And without the Hogarth case starting it all off, I don't know whether it would have grown quite like that. But it was a brilliant example of how you can use you know, the sort of argument that I think would probably have a red line under it if it was an essay in a logic class, and get away with it. Parliament passed the law very quickly. So that's my moment of amusement and frustration with the whole long story.
Yeah, I mean, it's so true. But, you know, the thing is that we're looking back, you know, over 200 years. At the time when that was one case and it wasn't, you know, momentous. I mean, it wasn't, do you see what I'm saying? So they want to know what the consequences of that one case would be. But looking back on it, absolutely, David, is because that case basically opened the decision that was made to extend copyright to engravings, opened the door to extending the subject matter of copyright from books to absolutely everything else, and to basically anything that has the modicum of originality, which is
Very,
almost
very
nothing.
low modicum. Yeah.
Yeah, I mean, your doodles on a piece of paper would qualify as a copyrightable
This
work.
is copyright D. Bellos 2024 already. Copyright
Yeah.
arises on creation, which is
Yeah.
also a slightly crazy idea, but there we are.
Which, again, on its own, you can see why you would want to do that. If any of these one things, you see, I think that's the story of this book, is that any of these one things, you can see why you would want to have that.
Right.
Okay, so for example, copyright arises on creation and you don't have to register it, and there are no formalities associated with that. Okay, there was a time when formalities were associated. You had to put an R and you had to put a C in a circle, but those were removed. And the arguments in favor of those are that people shouldn't be burdened. It's not fair. And you can see that argument, right? It's not right if you as an author, you didn't know, and suddenly, your work is injected into the public domain. There's some validity to that argument. There's some appeal to that argument. But as a whole, if you look at all of these things that we go through in the book, as to, beginning with how copyright actually came to be, we actually talk about the system that preceded it. And in a funny way, we connect the dots, saying, in some ways, we're actually going back to that system,
Right.
actually, which copyright was supposed to, replace that old system of privilege and patronage that existed before copyright. But anyway, these things all came together. The extension of the subject matter of copyright, the extension of the term of copyright from, 14 years to what it is today, which is life of author plus 70 years, which is,
a long, long time.
Long time. The extension, the removal of the requirement of all formalities, the extension of copyright to all countries, so that if you write a book, or you don't have to write a book, David's doodles on that paper are copyrightable, and that copyright is enforceable not just in the US, but in almost every country in the world.
That's right. All the member states of the Berne Union, which number now, I think, about 180 something. There are only about 12 territories that are not covered by international copyright agreements, and the only one of those that is of any size with its own significant cultural industry is Iran. Most of the other non-members are really quite small places, Pacific Islands and so forth.
And, so the other thing that we talk about in this context in the book is, not only did copyright itself morph from a very sort of a discrete law applicable to a very sort of discrete niche product at the time, books, but it also spawned a whole series of other laws that are making it a lot more difficult for people to use other works of the mind. And here I'm talking about trademarks and trade dress. The concept of trade dress, for example, I can explain it very quickly. A trademark is basically what you would know as a brand. It's an identifier of source, right? So usually a trademark is a name, Coca-Cola, Nike, things like that. But that law has also expanded very widely to cover all sorts of things, because of the way that copyright expanded. Those expansions of copyright extended into trademarks. So, for example, UPS's color, UPS's distinct color, which you might recognize, is trademarked. And unlike copyright, that has no limit. As long as UPS is using it, no one else is allowed to do that. Okay, so that was also something that we discuss in the book, that it's sort of a leak, shall we say, of the concept of copyright that leaked into, you know, another branch of the law. Other branches of the law also similarly went along. The right of publicity, you might have heard of this. It's a state right in the US. There's a right of publicity where no one is allowed to use your image or your voice in a commercial way for profit. Well, and that's independent of copyright. But it was influenced by copyright, and its term is similarly being, you know, extended and equated with the term of copyright, most recently in California, which granted a post-mortem right to the right of publicity of 70 years. So,
and that means that you can't show a photograph of, let's say, Humphrey Bogart in a Burberry Macintosh without paying a fee to whoever owns the Burberry Corporation in any published work, in anything that is circulated or indeed even put up on the web. And, you know, Humphrey Bogart's been dead a long time, but the Burberry Corporation is still there. Yes, I mean, what we chronicle really in the later chapters of the book is the way in which more or less everything has been privatized now. And if AI didn't exist, there is still a reason for raising an alarm and saying you should really think about this. Do you actually want every photograph you take with your iPhone to be a property such that nobody else can use it without your permission? It's ridiculous.
or
Well,
at least it's worth a debate.
yes.
I mean, I practice in this area, and I mean, there is certainly a purpose. It certainly does serve a purpose, but
Yep.
what we're encouraging is for people to have a debate at least, and you know, the AI is raising the issue not because of what we're saying here, that basically everything, the products of the mind have come under this enclosure. And that's a happenstance of history. And we're saying, do we really want that? Do we want everything to be enclosed? Or do we want people to be able to have access and use? And does that actually, you know, this issue, for example, has come up in the context of the fashion industry in the US. Because in the US, copyright has not extended into fashion the way that it has in Europe, because the US has resisted so far the extension of copyright to what's called useful objects. Now, the fashion industry has made some inroads into that, especially some recent cases where, like, a banana costume was deemed to be a creative work of art rather than a useful article of clothing.
It's certainly not very useful.
Right. So the question, so in the fashion industry, there have been some discussions as to, you know, whether the fact that you can actually get inspiration from other people's work, reuse other people's work in a way without infringing the copyright, does that actually, you know, encourage more creativity in the fashion industry? And there are some people who have come out and said, yeah, it actually really does. So this is something that I think we're trying to say, that, you know, it's gone too far in one direction. And I think that now, with these arguments around AI and whether AI should be allowed to use these, whether the output of AI itself should be copyrightable, it is a good time to revisit the whole question, rather than to look at these as individual cases to be decided.
Right.
That's right. Yeah, and if I may chip in my bit there, I also would like people to learn and realize and remember that uh, um, uh, many vibrant cultures and periods of cultural growth have occurred outside the grip of copyright. And people may not realize this, but of course, the world's most populous country, China, and the world's largest country, the Soviet Union, did not really have any recognizable copyright laws for the bulk of the 20th century. And the United States, although it had a copyright law, was basically a pirate nation from 1790 through to the very end of the 19th century, since it only allowed copyrights in US citizens. So in the period of America's growth and expansion, it was able to reprint books from Britain and translate books from French and German and elsewhere without any concern for copyright. And it did not do this country any harm because, as you know, literacy increased and it built a vibrant and active literature and publishing and printing industry in that period. So it does not follow that restrictive ownership of intellectual property rights encourages anything at all other than the accumulation of larger profit.
Right. Well, it's actually a perfect segue. We're going to get to we have several questions, so we're going to enter our Q&A from the audience portion. But before I ask the first question, I do want to mention, of course, Mark Twain fought and was very outspoken about copyright law during his lifetime. Copyright is actually what really started his all-white suit, which is what he's really well known for, his don't give a damn suit that he wore later in life. He wore it while he was testifying about copyright law in front of Congress. And it got so much attention because he was wearing white in December that he decided to wear it the rest of his life. So there's that interesting tie between Twain and copyright. He was really fighting to have copyright be for the life of the author plus an additional 50 years, hoping it would help his children. And in 1909, they decided to add 14 years. So he didn't quite get what he wanted, but this is something he really fought long and hard for. The Canadians and their copyright were his biggest adversary when doing this. So I just wanted to mention that little nice tie. I want to get to the audience questions. So the first one we have is, who can publishers continue to use a known author on books even after they have died? I know this happens in children's literature.
Sorry, can you repeat that question?
Sure. Why can publishers continue to use a known author on books even after they have died? I know this happens in children's literature.
Well, because copyright lasts for 70 years post-mortem. And so it belongs to the heirs of the writer and most likely, to the publisher who published them and who acquired the license to exploit those works for the duration of copyright.
All right. Someone was wondering if you could identify the big 6 corporations that we mentioned at the beginning.
Alex, can you hear us?
Yes.
Yes. Let me see if I get it right. Disney, Amazon, Meta, Google, Microsoft, and
Apple.
Apple. That's right. Thank you.
You got it.
Thank you. All right. So our next question. So I'm assuming individual authors should still copyright their work, correct? Did you copyright your book, or is this just a meaningless exercise? If it should be done, what protections does this maneuver give to the individual author?
Alex, do you want to take that one?
Yes. Yes. Okay. So individual authors, of course, should register. When you say copyright, I'm assuming you mean register your work with the Copyright Office. Because as we explained, copyright comes into being on creation. So you don't actually need to do anything in order to gain the full protections of the copyright law. However, registration does provide some benefits. One is that if there's an infringement, you get statutory damages. That's actually quite important, of up to $150,000 per infringement. And you can get attorney's fees. So
If you win.
that you do register. In practice, the way that it works and the way that it worked for us is that the publisher registers the work. So the author enters into an agreement with the publisher, pursuant to which the publisher basically gets a license, usually an exclusive license, to publish the book. And as part of that, the publisher will then and register the copyright and enforce the copyright on behalf of the author.
Thank you for that. We have just a couple more. So here we have one. The intellectual property clause of the U.S. Constitution only empowers Congress to generate laws to promote the progress of science of the useful arts. As the present state of U.S. copyright laws is clearly being used for exclusionary and profit purposes by a very few corporations, could it be argued that the laws should be reconsidered and written de novo?
Yes.
Yes.
Yes. I've never seen it argued, and we don't actually say so in our book. But one of the implications of what we're saying is that the current IP law, the Copyright Act of 1976 that came into force in 1978, is quite plausibly unconstitutional. Because it really does not correspond to that Clause 8 of Article 1 of the US Constitution.
Okay. All right, couple more. If I quote
sorry, can I just go back to that question?
Sure.
I don't think that will win the day in front of this Supreme Court.
Yes.
Let me just be clear on that. We are not that at all. I don't think we would even get one vote. Though the arguments, the judges might find the arguments intriguing and interesting. And by the way, the Supreme Court never splits in the usual way when it comes to IP issues. That's the other very interesting thing. You know, we talk about, liberal judges and conservative judges and all that. They never split that way when it comes to these copyright and trademark issues. That's another interesting thing. So
that is very interesting. Okay, final couple questions. If I quote from a copyrighted source, and if I mention and give credit to the source, am I breaking copyright law simply by virtue of quoting the source?
Yes and no. You're not breaking the law, but you may be committing an infringement. You're allowed to do that under the doctrine of fair use, but the section of the US law that establishes fair use is formulated in such a way that you can never really know whether what you're doing is going to be considered fair or not. Given that the owner of the right in the work that you're quoting is ultimately going to be a large publishing house that belongs to a large financial conglomerate, if they send you a letter saying, no, you may not do this, you would be wise to withdraw your quotation and or pay them whatever pound of flesh they're demanding. In fact, your publisher of your book won't really allow you to publish it unless that permission has been cleared, because nobody in their right minds wants to be the defendant in an infringement case, because they're so expensive to defend, and the outcome, as Alex will tell you, is pretty much imponderable. I mean, you don't know what a jury is going to decide.
Yeah, I've litigated fair use cases. It's very fair. And David is right. Publishers wouldn't. And I would recommend to everybody who would like to rely on a defense of fair use to consult with a lawyer who knows this area, rather than to just go it on their own.
And I think that's a terrible constraint. I mean, it's crazy that you should have to do that. In academic publishing, even in academic publishing, publishers are now insisting that scholarly authors clear all their quotations.
And you kind of are one of our other questions, what constitutes an infringement, which you did bring up that up. So we have one more question. Are you both okay with answering one more before we conclude?
Sure.
Perfect. So this is a comment and a question, which I think is great. Thousands of students graduate from art programs and writing programs every year without having any clue that they are creating copyrights at the same time they are creating art and literary works. It is a massive omission of universities. I developed a course similar to yours, which I taught at art schools in the 90s. Why do universities resist teaching this?
No idea.
David can answer that question. He teaches at a university.
No idea. Or rather, I suppose because teachers of literature and art and of other creative subjects are really quite ignorant about the law and live in a kind of state of fear and trembling about, not using the Xerox machine too often. The copyright laws affect almost everything we do and constrain us, and yet they're like the elephant in the room. People don't see it. So thank you for teaching such a course to art students. There should be more. And we should get on with repeating our copyright course at Princeton and hope that others will imitate.
That's great. Well, I want to thank you both so much for taking the time out to join us and have this conversation and answering questions. As I said, I loved reading your book. I think it's absolutely fascinating, the history of copyright, the discussions about what's taking place today, what could happen in the future with copyright. So for everyone who joined us, I highly recommend purchasing this book and educating yourself while at the same time really enjoying yourself. So Omar is putting the link to purchase the book in the chat. So before you leave today, hopefully you will go and grab this book and really enjoy reading about what these lovely authors have written. So thank you both, David and Alex. Really appreciate your time and for joining us. And thank you for doing this really important work.
Thank you for having us.
Thank you.